Hey everybody, thank you all for joining today's or this year's ethics seminar. We'll get started here in a couple of minutes. First up, we have Bruce Smith, who will be speaking about doing an ethics update this year. And then after that, we will have Lewis Jenkins, followed by Laura Chastain. So Bruce, whenever you are ready to get started, you should be able to turn your video on. If you have any issues, just let me know. If anybody has any questions, that you can use the chat function or the Q&A function at the bottom, and I will keep track of those and ask our presenter whenever he wants to take questions. So Bruce, you should be good to go.
Good afternoon. It's always a pleasure. One of the things that Lewis Jenkins and I look forward each year is presenting the West Tennessee Legal Services Annual Ethics Seminar. Thank you so very much for inviting us again. This is intended to be interactive and participatory. So if you have a question, please don't hesitate to ask it. There is a handout, and it's a bit different this year. It does have summaries, but the summaries are not as lengthy. I have included several summaries of several matters which Laura Chastain is going to address there. So this handout is always intended to be something that you, as a reference, that you can look back at during the course of the year. Again, thanks for inviting me. And if anybody wants any of these materials, I can email them. The handout provides my contact information. I'm also glad to discuss an ethics scenario with you offline, and to send you any of the materials that are discussed in this handout. Advertising, there were significant changes to Rule 7.1, and those are going to be discussed by Laura. The handout does has a summary of them. In terms of advertising and solicitation, there is, as you know, there is a prohibition in our rules about solicitation or contacting individuals during a 30-day period after a serious or catastrophic event. You may remember the Chattanooga school bus crash, in which numerous students were killed, and many others injured. A law firm from Texas sent folks to Tennessee to try to sign up clients, family members of the injured victims and of the students that were killed. A Chattanooga jury found that the Texas law firm, its owner and its agents, were liable for consumer protection violations and the unauthorized practice of law in soliciting the families in this fatal 2016 bus accident. They were ordered to pay $96,000. Certainly a very significant message being sent. So if there is a catastrophic event or serious injuries in a manner of which you're aware, please check the rule and make sure that you understand and properly navigate the restrictions on solicitation. Attorney-client privilege and the duty of confidentiality. There's an opinion that is not included in your handout, but want you to be aware of. It is Moore, Moore Freight Services, Inc. versus Mize. It's a lengthy Court of Appeals decision out of Knoxville, decided February 3, 2022. It is the basic facts. The basic facts are that a chief operating officer was named, left. The plaintiff corporation filed suit to enforce a non-competition agreement, and they sued the former chief operating officer and his current employer. The corporation alleged that it had terminated employment for cause based on learning that he was involved in a payment scheme with a customer. So an internal investigation was launched by both the corporate entity and by the customer who was alleged to have participated in the scheme. Outside counsel was retained to conduct the investigation. So this gets into the role of lawyers as investigators. So discovery requests were filed, and the defendant, the former chief operating officer, wanted every document pertaining to the corporation's internal investigation. They resisted and defended on the basis of attorney-client privilege, common interest privilege, and the work product doctrine. The trial court inspected some documents in camera and properly drew a distinction on the work product side as to whether materials, documents were fact or work product or opinion work product. Everyone agreed that there was no opinion work product. So there are very good discussions of those doctrines. This was raised in the context of a discovery dispute on interlocutory appeal. This is very much worth looking at if you have an attorney-client privilege, common interest privilege, or work product protection issues. Another aspect of attorney-client privilege and the duty of confidentiality. And remember that there is attorney work product, but we also have in Tennessee a duty of confidentiality, and it is stronger than the attorney-client privilege. And remember that attorney-client privilege is both statutory and common law, and it survives past the end of the matter and the death of the client, unless the matter has become publicly known. Disciplinary counsel continues to receive complaints that are based upon a lawyer filing a motion to withdraw, and in the motion itself or in an affidavit in support of the motion, the lawyer discloses confidential information or privileged information. So be aware of that. Read your motion and affidavit carefully. Perhaps have someone, a colleague, take a look at it just to be sure, because when the motion is argued, your adversary is going to be there and will be very interested to get information. And again, a lawyer does not want to be in the position of having waived attorney-client privilege. Attorney fees. A lawyer received a flat fee for a divorce, but failed to put the unearned fees in his trust account at the beginning of the representation. received a public censure. That's the Darnell case. The awards of attorney's fees and costs after dismissal of a claim pursuant to TCA 20-12-119C. This is a fairly recent statute which says that Tennessee follows the American rule, which says that each party bears his or her or its own attorney's fees unless there is a contractual provision or a statute which authorizes recovery of attorney's fees. The 20-12-119C provides that if a complaint or counter-complaint is dismissed for failure to state a claim upon which relief may be granted, the prevailing party in the motion can recover attorney's fees and expenses. Donovan versus Hastings, page 3 of the handout, at the very bottom, is a construction dispute between a homeowner and a contractor. The homeowner entered into a contract with the contractor, paid $130,000, was very dissatisfied with the work, and filed suit against the contractor. The contractor filed a counter complaint and then subsequently filed an amended counter complaint which revised its damages claims. The trial court on the homeowner's motion dismissed the amended counter complaint for failure to state a claim. The homeowner then filed a motion for attorney's fees and costs under TCA 20-12-119C. The trial court granted the motion, but only awarded attorney's fees and expenses from the date after the counter complaint, the amended counter complaint was filed. The case went up to the Court of Appeals and then to the Tennessee Supreme Court. And the Tennessee Supreme Court said that the trial court's award was in error and that it should not have been limited to attorney's fees and costs incurred after the date the amended counter complaint was filed. The award was vacated and sent back to the trial court for reconsideration of the award. Remember also that if you're drafting a contract, practice pointer, repeating one that we repeat periodically, please remember that for your client to be entitled to recover attorney's fees, the written agreement must expressly use the terms attorney's fees or including reasonable attorney's fees. Language that dances around the magic words are problematic and actually provoke litigation and may be held insufficient to an award of attorney's fees. Words such as litigation expenses. Courts, when confronted with consideration of an award of attorney's fees, are looking for contemporaneously prepared time records. It is often when records are reconstructed, it's you may actually lose time that you actually spent on it from not being able to accurately reconstruct. Candor toward the tribunal. There is a very important case that Laura is going to discuss, Harris versus Board of Professional Responsibility. It's discussed at pages 4 or 5 and the top of page 6 of the handout in very generous terms, very broad terms. A lawyer breached his duty of candor toward the tribunal by his testimony in a juvenile court proceeding. And the Tennessee Supreme Court reiterates, and I've quoted some of the language in the handout, that lawyers have a paramount duty for trust of truth, and that that duty is more than simply refraining from committing perjury. The duty of candor toward the tribunal and to the system of justice prevails over everything, because that's part of the basis that the public has confidence in our justice system. Page 6 of the handout, the Lee case, a lawyer was suspended for 3 years, entered a conditional guilty plea. He knowingly failed to timely comply with an injunction issued by the United States District Court and misrepresented to the court that he was unaware of the court's order. That breached the lawyer's duty of candor toward the tribunal. Communication with persons represented by counsel on page 6 and page 7. There are a couple of ABA formal opinions this year. ABA formal opinions are not binding on the board or disciplinary council. They are a helpful research source for lawyers, particularly on topics where the Board of Professional Responsibility has not weighed in on the subject. The board will indicate its approval of some, but not all ABA ethics opinions, and in those instances, Tennessee lawyers can rely with confidence on those ABA opinions. One of the reasons for this is that the Tennessee rules of professional conduct are not verbatim identical to the ABA model rules of professional conduct, which are from time to time updated or amended or revised. So again, before relying on the ABA model rules of professional conduct or a formal opinion issued by the ABA, please compare the Tennessee version of the rule against the ABA version of its model rule. Formal opinion 502, communication with a represented person by a pro se lawyer. And that last phrase, lawyer after pro se, is significant. There is an increasing amount of litigation in which individuals choose to self-represent. And Rule 4.2 is the so-called no contact rule. A lawyer cannot directly communicate with a person who is represented unless the person's lawyer consents. All communication with a represented person is to be through the lawyer. So this opinion is based on, to address the perception by some pro se persons that Rule 4.2 does not apply to them. One, they're not a lawyer. And two, they don't represent another person, they represent themselves. Rule 502, it's opinion 502 says that that unless the pro se lawyer, because a pro se individual is acting as his or her own lawyer, has the consent of the represented person's lawyer, he cannot communicate directly with the other represented person about the subject of the representation. That communication is prohibited. The opinion does not address how that is to be enforced. Formal opinion 503. is significant. It deals with reply all in electronic communications. The practice is that email and text threads grow and grow and grow. Often there is a very lengthy, extensive list of recipients. The difficulty arises when a lawyer sends an email or a text and includes his or her client as getting a copy of that email. So the receiving lawyer is going to respond to that email or text. The issue is, often the way it's done is by hitting reply all. Does the sending lawyer consent to the receiving lawyer directly communicating with his or her client by including the client as getting a copy of the email? ABA answers this question, yes. It's an implied waiver. Discussion on pages 6 and page 7. ABA recommends that the best practice is do not include the client as a recipient of the email. Send a separate email or text to the client. It's an implied waiver of implied consent. So on the receiving lawyer's end, he or she is free to respond with reply all, even though one of the recipients of it will be the client on the other side. But the implied consent is only for the topic in the first email. It is not a blanket consent to include the adverse client in all subsequent communications. Only the topic that is in the initial email. If the lawyer sending the email wants to avoid implying consent when copying the client on emails, the sending lawyer should separately communicate with the receiving lawyer saying, hey, I am not consenting to you replying directly to my client as receiving a copy of your response. Generally, the better practice is to send a separate text or email forwarding the text or email to your client. A separate forward is better than BCCing the client, because in some email platforms, the client's reply all to that email would still reach the client. So paper communications, a letter where it goes out to a group and CC or copies to, and the client is listed. This does not apply to paper communications. There is no accepted practice right now that indicates that copying a client on a traditional paper letter, that the sending lawyer has impliedly consented to the receiving counsel sending a copy of the responsive letter to the sending lawyer's client. Again, part of the reality underlying this is that email and text message replies are often sent quickly, and the client may reply hastily with sensitive or compromising information, which of course it is intended probably to go to his or her lawyer, but winds up going to adverse counsel as well. Conflicts of interest on page 7 of resource. Frey-Vogel on conflicts is a great research tool on any issues pertaining to conflicts. And the bottom of page 7, top of page 8, the Fallon matter. Mr. Fallon received a public censure. He represented a man who was charged with first-degree murder, and he also represented the man's wife, who was charged with conspiracy to commit the same murder. Mr. Fallon's daughter worked in his law office. She agreed to serve as legal representative of both the man and his wife in exchange for payment for her services. She used her authority under a power of attorney to make at least one payment of expenses to the lawyer. The lawyer didn't have a written fee agreement, didn't otherwise discuss with them the potential conflict of interest. There was a significant risk that Mr. Fallon's representation of the wife would be materially limited by his representation of the man, her husband, charged with the murder. Also, Mr. Fallon did not discuss with his client the business relationship they entered into with his daughter under the power of attorney. That should have been done before the business relationship was entered into. He received a public censure. Criminal convictions on page 8 and top of page 9. Every year there is a list of attorneys who are convicted of criminal offenses. You can see the list, this year's list for yourself. The Hobson case, aggravated assault and theft of property. The Neglia case, bribery of a public servant and conspiracy to violate the Travel Act. This involved an attorney in Memphis who was trying to get Memphis Police Department records before they were available to the public. Bribery of a public servant, an official misconduct, the Adams case, violation of order of protection and violation of bond conditions. The Pope case, he received a public censure. The Reguly case is interesting. A missing child was recovered at a lawyer's home. She eventually was tried and convicted of 2 felonies and a misdemeanor. She was sentenced to 2 years of supervised probation and 30 days in the county jail for the 2 felony convictions, and 11 months, 29 days on a misdemeanor charge, of which she was to serve 10 days and the remainder of the sentence suspended. All of this to be served consecutively. The Tennessee Supreme Court referred the matter to the board for determination of the disciplinary punishment to be imposed on Ms. Reguly because of their conviction of a serious crime within the meaning of the Supreme Court rules. She filed a petition for dissolution or amendment of the temporary suspension, alleging that errors occurred during the criminal proceedings that call her conviction into question, and also that summary suspension denies her due process. The Tennessee Supreme Court, within about a week of her filing the petition, denied the petition. Criminal law, a lawyer entered a conditional guilty plea admitting that he failed to reasonably respond to his client's request for information about the status of his criminal case and failed to diligently represent his client for about 2 years. That's the Freeman case. The of the failure to respond to a disciplinary complaint every year. There are lawyers who are temporarily suspended and also subsequently disciplined for failing to respond to a disciplinary complaint. At least 4 lawyers, and there may have been more, were temporarily suspended in the past year. The bottom line is that if a disciplinary complaint is filed, and it is always has a deadline for a response. Disciplinary counsel will grant an extension to file the written response. It's important to contact disciplinary counsel before the deadline rather than after the deadline. There are numerous instances in which disciplinary counsel is granted multiple extensions to file a response or to respond to a subsequent request for information. Temporary suspension, misappropriation, the Werner case, lawyer was misappropriated funds and was deemed to be a danger to his clients and to the public at large. The Tennessee Supreme Court has the authority, and each year now we're seeing decisions of the Tennessee Supreme Court that is rejecting discipline that is either recommended by a hearing panel after a hearing or a conditional guilty plea. We have an example of each this year. In bottom of page 9, top of page 10, a hearing panel decision suspended a lawyer for a year, ordered him to serve no less than 90 days on active suspension and the remainder on conditional probation. Suspensions now can have conditions of probation. The Supreme Court felt that the lawyer's punishment was too lenient and not comparable to punishment imposed in similar cases. The indefinite length of the suspension also caused trouble for the Supreme Court. The court proposes to increase the punishment. So there's a process where the record is sent, the respondent attorney files a brief, the board then files a brief, and the Supreme Court makes a decision. Often this is done without oral argument. The Baker case also mentioned it was a conditional guilty plea, which the Supreme Court rejected due to the board's concerns that the recommended punishment, particularly the period of active suspension, is too lenient. So again, if a lawyer negotiates with disciplinary counsel and enters into a conditional guilty plea, the Tennessee Supreme Court reviews every decision of a hearing panel, every conditional guilty plea, and one of the purposes is to make sure that disciplinary punishment is uniform across the state. So it is, if a lawyer negotiates a conditional guilty plea, it ain't necessarily a done deal. Disbarments, again, one of the most serious, it's the perhaps the most serious punishment offense that a lawyer can commit. Lawyer was permanently disbarred in order to make payment of $10,000 restitution. The Tennyson case, he wrongfully retained $10,000 belonged to his client for his own financial benefit, refused to return the amount despite a written fee agreement requiring that the funds be immediately refunded. And he knowingly deceived his client as to the process where the client could receive payment of the misappropriated funds. The permanent disbarment is again a fairly recent development. Tennessee is one. Tennessee is now can have suspensions up to 10 years. That's one of the longest in the maximum periods for a suspension in the nation. Ms. Chastain may be mentioning that in her presentation. But permanent disbarment means that a lawyer can never apply for reinstatement and will never again be licensed to practice law in Tennessee. The former rule was that a disbarred lawyer could apply for reinstatement after serving 5 years on disbarment. The McClellan case, a lawyer consented to disbarment because he could not successfully defend the charges. He misappropriated estate funds, attempted to conceal the misappropriation, made misrepresentations to a court, failed to abide by a client's decision regarding the dismissal of a pending lawsuit, failed to reasonably consult with a client about the means by which the client's objectives were to be accomplished, and failed to obtain the client's informed consent before taking action. Again, lawyers recommend and advise, but decisions on many issues belong to the client. He also failed to keep client information confidential, failed to withdraw after a conflict developed, and allowed a third person to direct his professional judgment, failed to comply with his ethical obligations upon discharge from representation, and failed to comply with the obligations of a suspended attorney. At the top of page 11, lawyer received a retainer fee but failed to provide services, failed to file complaints, misled the client to believe their complaints had been filed, failed to appear for scheduled hearings and motions, failed to return unearned retainer fees. The lawyer was permanently disbarred. Suspensions. Lawyer, Mr. Finney, was suspended 4 years, of which 3 years are active, the remainder on probation. He failed to reasonably communicate with 2 clients the status of their cases. Ms. Chastain will discuss with you the large percentage of complaints that she sees that arise out of communication and or neglect. The Harris case. Lawyer was suspended for 2 years, of which 60 days was active suspension, and the remainder on probation, subject to the lawyer making restitution within the first year of probation. The lawyer did not make the restitution within the first year of probation. The board filed a petition to revoke probation. It was granted, and the lawyer was suspended for 2 years of active suspension. With the Richardson case, lawyer was hired in a vehicular accident case. He sent a letter of representation to the insurance company and responded to the insurance company's letter requesting information. More information was requested. He didn't respond, ignored 4 additional letters that the insurance company sent, and did not inform his client of those letters. He received a public censure. Divorce, the Fielden case, it was a case where a lawyer received a suspension based on diligence. File retention. The Judkins case, bottom of page 12, top of page 13. There are 2 opinions, opinion 160 and 160A. And essentially, among the things that they establish is that the file belongs to the client. The entire file belongs to the client. and the lawyer is obligated to deliver the file, the original file, to the client. If the lawyer wants to copy some or all of the file, the lawyer can do so at the lawyer's expense. So, of course, lawyers also have attorney's lien rights. So it's well established that a lawyer cannot hold on to the client's file, make them hostage to for payment of the lawyer's fee. If a client has paid for work, all of those documents, electronic and hard copy, have to go to the client because they've been paid for. The remainder, the lawyer has a lien on. But there is also the client's need for documents or records or information in the ongoing matter. The issue is, can the lawyer hold on to those records, the portion of the file, that portion of the file for which he has not been paid, or does the client's imminent need for purposes of the underlying matter prevail over the lien? The answer generally is that the client's need prevails, but in delivering the file, the lawyer does not waive or relinquish his or her lien rights. The Judkins case, Mr. Judkins asserted attorneys, the lawyer was fired in a divorce. He refused to immediately transfer the file to the new lawyer. He asserted an attorney's lien in the litigation and over the file materials pursuant to Tennessee common law and TCA 23-2-102 for securing payment of his fee. So attorney's liens are both common law and statutory. The assertion of these lien rights was lawful, but the delay in transferring certain client file materials violated the lawyer's duty to his former client. He additionally failed to communicate with his clients about the terms of the fees to be paid or the manner in which the fees would be paid. He failed to provide updates as to the amounts that are owed during the course of the litigation, pardon me, and did not notify his client as to the amount of fees that were owed until he was terminated. So finally, in an attempt to assert and defend his valid attorney's lien, again, it's a valid lien, he sought and received permission from the court to intervene. But following intervention, he attempted to participate in the litigation beyond the extent the court deemed was necessary to assert and defend his lien rights. So for those reasons, the lawyer received a public censure. This is a very good example of what can happen when a client is fired and a lawyer wants to assert or needs to assert lien rights. Public censure, client was terminated the representation. The lawyer failed to turn over the file to successor counsel for over a month. And the lawyer received a public censure. Forging a client's signature or signing the client's name without the client's permission. This is something that's being seen on an increasing basis where someone is signing someone else's name. Here, pardon me again, in the Darnell case, the lawyer failed to provide sufficient oversight of his legal assistant, who prepared a forged final decree and a letter without the lawyer's knowledge, in violation of Rule 5.3, the lawyer's duty to supervise non-lawyers. He also didn't have sufficient protocols in place to reveal that the client's divorce petition had not been filed. He also received a flat fee and failed to place the unearned funds in his trust account at the beginning of the representation. The lawyer received a public censure. Impaired lawyers and judges. Laura is going to discuss with you very important developments in attorney wellness and well-being, an extremely important topic, and one that has taken on greater meaning and significance during and after the pandemic. Just a few library resources for you on page 13. The board publishes the mental health and substance abuse information for Tennessee attorneys. It was in board notes in 2016, which is available on the board's website. Information as to TLAP, Executive Director Buddy Stockwell's contact information is available. Mr. Stockwell operates on the basis of fitness for duty. Evaluation as to whether a lawyer is fit for duty based upon physical evaluation. Fitness for duty is the same test that is used for airline pilots, railroad engineers, other persons in extremely safety sensitive positions where if a person is not fit for duty, great harm can potentially result. The Harvard Business Review on page 14 issued difficult conversations navigating mental health at work. It's a reading list, and it's very helpful if you are concerned about someone in your firm or a colleague. It's a good resource for having what could be a very difficult conversation. The Graham case on page 14, a lawyer was in substantial non-compliance with his TLAP, Tennessee Lawyers Assistance Program monitoring agreement, and was temporarily suspended. TLAP can be a lawyer's best friend because it can get help and can assist the lawyer in being able to practice law in an appropriate manner. But if a lawyer enters into a TLAP monitoring agreement and fails to comply, then the lawyer can find himself or herself temporarily suspended. And it's not a gotcha game. TLAP goes to extraordinary lengths to work with lawyers and to prevent the lawyer from becoming part of the disciplinary system. But if there has to be involvement, cooperation, participation by an attorney. Judicial disqualification or recusal. There is a robust body of law that's developed on judicial disqualification and recusal motions under Supreme Court Rule 10b. There are decisions each year which dismiss Rule 10b appeals because the lawyers failed to comply with the mandatory requirements of Rule 10b. These appeals are handled on an accelerated basis. And by and large, the Court of Appeals and the Tennessee Supreme Court fulfill their obligations under the rules. They handle these appeals very promptly and get decisions out very quickly. But they expect The only thing that the appellate courts are going to see is what the lawyer who files the motion to recuse or disqualify provides. So there are requirements, among other things, for a detailed affidavit as to the facts and circumstances which the movement alleges form the necessity for the trial court to recuse itself. Also, the motion itself, other relevant pleadings have to be provided. And the courts have warned, if you fail to provide comply, strict compliance is mandatory, and we're not going to give you a second chance. The Haddix case is an example, and there are several others that during the year which did not cite that where lawyers failed to comply with the mandatory requirements of Rule 10b, and their appeal was dismissed. There are a couple of opinions on the merits that are not in your handout. One is Balmoral Shopping Center LLC versus City of Memphis. It's a Western Section decision, pardon me, November 18. The underlying case is that Balmoral Shopping Center is located next to a very large high school in East Memphis, and they complain that the shopping center and the city of Memphis and Shelby County do a very bad job of controlling traffic when school is starting and at the end of the day, and the vehicular traffic is interfering with the operation of and with their tenants. They filed a lawsuit. Status conference was held, and there was a newly elected circuit court judge who was hearing the case. So within a week of the judge taking office at the status conference, at this status conference, the city discusses with the trial court judge that she had been one of the lawyers involved in the Beale Street Bucks case. Beale Street Bucks was an ordinance adopted by the Memphis City Council, which required people who were driving in the Beale Street Entertainment District to pay a $10 fee. That was on Saturday night. That was designed to prevent or reduce the amount of cruising and traffic congestion in this highly popular entertainment district in downtown Memphis. The judge was one of the lawyers for the plaintiff who was involved in that. So that was discussed at a status conference. And a week later, the city filed a formal motion to recuse. The issue, or one of the issues, was Rule 10b pertains to the specific matter in which the court is hearing. And the argument was that the Beale Street Bucks case was an entirely different matter, and the city's concerns that because of the high-profile nature and the arguments that were made in the Beale Street Bucks litigation, that there may be biased treatment by the trial court judge. The Western section said no, and affirmed the denial of the motion to disqualify or recuse the trial court judge. That decision, Western section, on November 18th, Balmoral Shopping Center versus City of Memphis. Ostermiller v. Ostermiller, pardon me, Austermiller. Case decided December 5th out of Nashville. The husband in a divorce failed a court-ordered drug test. So from the bench, the judge says, if I could put Mr. Ostermiller in drug court, I would. It's a 2-year program. I would certainly love for him to be in that. Unfortunately, he doesn't qualify because it's not for domestic. It's for criminal. In the order that was entered following the hearing, the judge wrote, the court made these suggestions only to help Mr. Ostermiller get well and beat his addiction so he can be a father to his 2 children. That went up to the Court of Appeals following the court's denial of his motion to disqualify the trial court judge. The motion, the decision not to recuse was affirmed. There is a decision where the Court of Appeals did reverse denial of a motion for disqualification. It is Clay, C-L-A-Y County v. Purdue Pharma, P-H-A-R-M-A-L-P. A very significant case, and the appellate court concluded that there were very serious concerns contributing to an appearance of partiality that mandated the trial court's disqualification. In addition to disqualifying the trial court judge, they vacated an order on substantive matters signed by the trial court judge while the recusal motion was pending. Under the rules, when a motion to disqualify or recuse under Rule 10b is filed, everything in the trial court stops until the trial court disposes of the Rule 10b motion. So that is a case where it is worth looking at just simply to see circumstances under which a recusal was deemed to be appropriate. The legal malpractice. Oh, one other thing on judicial discipline. The Judicial Ethics Committee issued an advisory opinion on March 29, advisory opinion 22-01, which states a judge or judicial candidate is now permitted under the Code of Judicial Conduct to personally solicit and accept campaign contributions. We're past the election, but again, that's a resource if it is something, a topic in which you are interested. The legal malpractice. A legal malpractice lawsuit was dismissed. The former client alleged that his former attorney failed to bring to the attention of the trial judge that a criminal charge against him had been dismissed and judicially expunged. The plaintiff claimed that that was a favorable determination on outcome on the merits for purposes of the underlying malicious prosecution claim. The lawyer filed a motion for summary judgment, which was granted. The Court of Appeals agreed that dismissal of a criminal charge and judicial expungement is not a favorable outcome on the merits for purposes of a malicious prosecution claim. The Court of Appeals also affirmed the lawyer's judgment of $1,000 on the counterclaim filed by the lawyer. There was a written fee agreement for $8,000 payment to be made in several installments. The lawyer, the client unilaterally withheld payment of the final $1,000 and came up, had a list of things that the lawyer said was supposed to do that didn't do, or deadlines that they had discussed by which things would be accomplished, and according to the client, they weren't, and that the lawyer failed to perform properly. The Court of Appeals quickly decided that there's a written fee agreement. Nothing in the written fee agreement permits the client to unilaterally withhold payment, and the client has to pay what the money that is owed to the lawyer under the terms of the contract. This is helpful, and it's a good reminder that of the importance of having an engagement letter or an attorney fee contract. Although you can send a letter or an email that confirms the basis for which you will charge fees, having a contract or an engagement letter at the bottom, accepted and agreed and provided back to the lawyer, can be very helpful if it becomes necessary to collect the fees. There is also an opinion, Westco Insurance versus Belfance. It's a Sixth Circuit opinion. It was decided on July 1. It's out of Ohio, but the basic facts, it deals with legal malpractice insurance. The question is, does your legal malpractice insurance policy cover sanctions that are imposed by a court? In this particular case, lawyers filed a couple of IDEA cases against school districts and lost. IDEA has an attorney's fee provision for involving frivolous litigation. So the question was, if a court compels a lawyer to pay a defendant's attorney's fees because the lawyer filed a frivolous complaint or litigated a case for an improper purpose, would the average attorney describe this fee award as a sanction? The court noted that legal community routinely describes attorney's fees awards as a sanction when a court grants it because of abusive litigation tactics. The Sixth Circuit held that because of this, there is no coverage under the legal malpractice insurance policy. An exclusion for payment of, or for defense of claims for sanctions or for payment of sanctions awarded bars recovery by the plaintiff. Litigation. A lawyer represented a client in an FED, a detainer action, didn't appear at the hearing. The case was dismissed. The lawyer received a public censure, and it was not more than that because the lawyer made a timely and good faith effort to rectify the consequences of his misconduct. The Campbell Brown case, bottom of page 15, lawyer was suspended, conditional guilty plea for a 1-year suspension, of which 60 days is active, the remainder on probation. She admitted that she accepted a fee, but failed to file the complaint, provide legal services in a diligent manner, expedite the client's litigation, and reasonably communicate with her client. She misled her client as to the filing of a complaint to quiet title. Each year, there are several cases in which a lawyer misleads a client, says that something has been done and it has not. And unfortunately for the lawyer, it's a simple thing for the client, and not necessarily, but for disciplinary counsel to call a clerk and find out if something has been done, and if so, when. or to call a register of deeds and ascertain the true status. The Edson case on the bottom of page 15, top of page 16. The lawyer was hired to represent a client, the lawyer was appointed, big distinction, appointed to represent a client in a dependency and neglect matter in juvenile court on, say, July 7, failed to, the adjudicatory hearing was set on July 29. The client calls repeatedly to talk to the lawyer, discuss the case. The lawyer fails to speak with the client until the day before the hearing, despite the multiple messages that were left. He failed to seek a continuance of the hearing until the day of the hearing, when he was actually in the courtroom, and he withdrew the request for a continuance when other parties objected. The client suffered potential harm. The Bearden case is a case that was mentioned last year, and it deals with disparaging a lawyer's adversary. Court points out that the Bearden case, very experienced, very able lawyer who basically savaged his adversary on multiple occasions in pleadings, and the Sixth Circuit says this is not productive and does not advance, does little if anything in advancing your client's position. Under miscellaneous on page 16, the Tennessee Supreme Court has eliminated all limitations on distance learning. So going forward, there were limitations that were increased during the pandemic. Now there are no limitations whatsoever. A lawyer can do all of his or her 15-hour requirement each year by distance learning. The middle of page 16, the Attorney General issued opinion number 2201 as to carrying handguns in buildings in which judicial proceedings occur. This is a comprehensive discussion as to whether citizens, judges, lawyers can carry handguns in facilities in which judicial proceedings occur, and under what circumstances. Bottom of page 16, top of page 17. The Nashville Bar Association had filed a petition to amend Rule 21 to require each Tennessee lawyer to complete 2 hours of the required 15 annual CLE hours in diversity, inclusion, equity, and elimination of bias. The petition prompted 57 written comments, which is a very large number for proposed rules. Quoted the language from the court. The court declined to make CLE in diversity, equity, and inclusion and elimination of bias mandatory. Admission to practice by comity. There is a requirement in Tennessee that if a lawyer is admitted in another state and wishes to be admitted by comity in Tennessee, he or she must have been actively engaged in the practice of law in 5 of the 7 years preceding the application for comity admission. It's a full-time practice requirement. The Network of Enlightened Women filed a petition asking that the full-time requirement be revised. Pointed out that there are many lawyers who work part-time, and of those that work part-time, a very large percentage are women. That's still under consideration by the Tennessee Supreme Court. There's also personal security and electronic security. Their phishing schemes are something that, and attempts to hack are something that we deal with in our personal lives and our professional lives. TVA today reported that the Georgia Bar Association issued a warning that there have been malicious emails, says request for information. The email makes reference to quote americanbar.org, and the phone number in the email is not operational. Members of the Indiana State Bar and Mississippi State Bar also reported receiving the same message. Be careful before opening emails with the subject line request for info. Be suspicious. In many instances, the phone number is the person who purportedly signs it is not an employee of the State Bar Association. Sex with clients, staff, and litigants. The Pruitt case. This is something that unfortunately occurs on a too frequent basis. Ms. Chastain is going to discuss the Pruitt case, but keep in mind that when a lawyer enters into a personal or romantic relationship with someone, that a conflict of interest can be easily be created. The lawyer is acting as a lawyer. The conflict is between the lawyer's personal interest and financial interests, and also the interests of the client to whom a lawyer owes paramount duties. The Trust Accounting Handbook is mentioned. Again, if you have questions or concerns about trust accounting, please look at this very good resource. It literally starts with how to balance the trust account. It also means that if a lawyer contends that he or she does not understand what is required as far as a trust account, that argument will not go far with disciplinary counsel. If a lawyer claims, I don't know how to do this, that argument also will not go very far with disciplinary counsel. Disciplinary counsel has little tolerance for trust account violations. Ms. Chastain is also going to mention to you the Tennessee Lawyers Fund for Client Protection. There was a petition this year to increase the amount of coverage available to victims under the Lawyers Fund for Client Protection, and to increase the annual registration fee by $15, with that money going into the fund. The board, disciplinary counsel helps administer the fund. The reason this is being mentioned in my presentation is that the cap is now $100,000 for an individual and $400,000 as to a particular lawyer. There's one, and there may be more than one lawyer who cumulatively have caused losses in excess of $1 million. So again, that is a very good resource for lawyers and advising clients who have been victimized by those in our profession who have violated ethical responsibilities and taken advantage of clients. one last case, Vaughn. It's April 21, 2022. He was permanently disbarred, ordered to pay restitution to his former law partners in the amount of $223,452.20. He was convicted of theft of property from his law firm partners and ordered to pay in excess of $223,000 in restitution. And that's, again, so as we go through these matters, in almost every instance, there is a victim that a lawyer is representing, for whom the lawyer is trying to get relief and justice. Andy, I'm glad to answer any questions.
We don't have any questions right now. If anybody has any questions, go ahead and ask them real quick before we move on to our next presenter. While we're doing that, I'm going to go ahead and make Lewis able to speak, so he will be ready to go for the next one. But if you got any questions, just let me know.
Or feel free to email me or call me.
All right, we're not seeing any questions. So Bruce, thank you so much for your presentation. Lewis, you should be able to share your screen and start your video and unmute. If not, just let me know and we'll get right on through to our next presentation.
Oh, Andy, I thought just 1 second, and I can start talking, but when you asked me if I wanted to do the video myself, I thought you meant did I want to control it from Zoom. That video is actually on my.
I got it. I will make sure you.
Okay, thanks. It was, I have it on my computer downstairs in my office, but I do not have it on this computer that has the Zoom on in the video conference in the conference room. And I'm sorry about that.
You're fine. All right, it should be up there for everyone.
There it is. Hey, everybody, good afternoon. Lewis Jenkins. And I'm not going to talk about David Davis. If you saw the original outline, it might have said that I was going to talk about David Davis, who was a circuit judge in the state of Illinois, was the campaign manager for Abraham Lincoln in his 1860 run for president, and then was appointed by President Lincoln to the U.S. Supreme Court and served as U.S. Supreme Court. And there's a fascinating incident from Davis's life in 1872, while a sitting Supreme Court justice. He was nominated by one party to be their presidential candidate, and it's fascinating. And maybe I'll get to do that next year. But I needed another trip to the archives at the Lincoln Presidential Library in order to finish that presentation, and I just didn't have time. I missed my opportunity to do that. So I'm going to talk about something that I thought was timely, especially now, and something that I personally have been thinking about. And so if you could move to the next slide there, please, Andy. So the first thing is we're going to look at several documents. Andy had some documents that he provided for you. I created a Dropbox share where I've got the formal ethics opinions, the comparison of the model rule to the Tennessee rule, and a couple of other documents, including the Florida Supreme Court opinion, which talks about the Florida rule on remote work. And I put those things in that Dropbox so that they'll be available for you after this presentation. In addition, this document is in there, and My email was there on the first page of this, the first page of this PowerPoint. So if you want it and you don't want to look around for it, shoot me an email and I'll send you the link to the Dropbox where you can get these things. During the pandemic, it became clear to lots of people that we were going to have some additional clarification on what it meant to work in one state and be licensed in another. Next slide, please, Andy. And so oh, wait, can I control that, Andy? Can I push that button myself and do that?
I don't think so, but I might.
Okay, all right. So the question is, if I'm licensed in Tennessee and I work remotely from a location in Tennessee, there aren't any multi-jurisdictional practice or unauthorized practice law concerns. It might raise concerns about confidentiality and technology, and we're going to talk about ABA Formal Ethics Opinion 498, which was issued in March of 21, but it doesn't raise MJP or UPL issues. However, if I'm licensed in Tennessee and I'm working remotely from another state, then in fact, some concerns do arise. There's some worry under Rule 5.5 as it's enacted by the various states that being physically present, especially if you're continuously physically present in another state. We're going to look at some of the facts of these various issues that have been decided around the country. If you're continuously present in another jurisdiction, but working, say you're continuously present in Alabama, but working remotely for a law firm in Tennessee, own Tennessee legal problems for Tennessee clients. What are the concerns that are raised by that? And so several states and the ABA began trying to address this during the pandemic. I'm gonna see. I wonder if I can make it go. Nope. Okay. So next slide then, Andy. I'm sorry. There are two ABA formal ethics opinions, and they're both in that Dropbox, by the way. So if you want to look at these, I put them up there. You can also get them off the ABA's website. But 495 is remote work and unauthorized practice of law. 498 is a discussion of concerns under other rules for remote work or what the ABA is calling in this formal ethics opinion, virtual practice. But some of these things are kind of surprising, and I thought we will go through some of the factors that are raised in this in both of these formal ethics opinion. Of the two, 495 is very short. It's only 4 pages long, and it basically concludes. It relies on a main ethics opinion that's existed since 2005, but it basically says that the committee that decided this for the ABA decided that a lawyer may practice law pursuant to the jurisdiction in which the lawyer is licensed, the licensing jurisdiction, even from a physical location where the lawyer is not licensed, the local jurisdiction, under specific parameters. A local jurisdiction has no real interest in prohibiting a lawyer from practicing the law of a jurisdiction in which that lawyer is licensed and therefore qualified to represent clients in that jurisdiction. A local jurisdiction, however, does have an interest in ensuring lawyers practicing in its jurisdiction are competent to do so. Now, the simple example of this is what I said. I'm licensed in Tennessee, and I am practicing law under Tennessee law. In other words, let's say this, I'm working on an appellate brief that will be filed in the Tennessee Court of Appeals. And now the Tennessee Court of Appeals has got electronic filing. So theoretically, I can file that brief from anywhere in the world. But let's take that one step further and say that I've reached that point in my practice in one of the New Jersey case that we're going to, one of the Florida and the New Jersey case we're going to talk about in just a bit involves almost this same thing. I've reached the point in my practice where I want to retire and sit on the beach somewhere, but I don't want to give up my practice altogether. So I stay associated or affiliated with my law firm here in Dyersburg in some way. And I write appellate briefs on my laptop and file them electronically. What are the implications of that for the unauthorized practice of law? And so that's what 495 says. And basically, and remember that these ABA formal ethics opinions are not binding in any jurisdiction. They are ethics opinions issued by the ABA that interpret the model rules of professional conduct, which are also published by the APA. And they are accepted as persuasive authority in virtually every jurisdiction that has the model rules of professional conduct. But it's not safe to rely solely on this. And formal ethics opinion 495 is just very short and just says, like I said, like I read to you a minute ago, that's not the unauthorized practice of law. Now it goes on to state that when you're in that other jurisdiction, you have to be careful not to state or imply that you're licensed in that jurisdiction. And the Florida opinion that we're going to talk about in just a minute, the guy was working in a house and was going to make sure that it was what was, he called it, invisible to Florida for all intents and purposes. But one of the things that 495 says is be careful about websites, be careful about any information that might even imply that the lawyer is physically located somewhere where they're not licensed to practice. And they relied, as I said, on this main formal ethics opinion, which was really the first jurisdiction in the country to address this issue. And then we're going to talk about 498, about some of the concerns that come up with respect to what happens once you've solved the UPL problem, okay, and you're sure under 5.5 of both the jurisdictions, the licensing jurisdiction and the local jurisdiction, that I'm authorized to do this and not breaking any rules by doing it, then what are the, really 498 is about what kinds of technological concerns arise for this kind of remote work or virtual practice. Okay, let's move to the next slide. These are two links. There's a law firm that prepared and put on its website in 2021, and it doesn't look to me like it's been updated since it was originally written in 2021. However, this is a jurisdiction by jurisdiction summary. What the challenge is here is that I've got to look at Rule 5.5 in Tennessee and the rules of unauthorized practice in Tennessee. And that's my licensing jurisdiction. And then I've got to look at the Rule 5.5 and the UPL rules in what the ABA calls the local jurisdiction. In other words, the place where I'm sitting on the beach. Say, for example, that would be South Carolina, or say Florida. I included the Florida Supreme Court's formal ethics opinion, or excuse me, ethics opinion on this issue because here in West Tennessee, probably, I would think most likely that's the most likely place where people might retire and want to work privately. There's also a very good article from the Illinois Supreme Court Ethics Education Senior Counsel, and I gave you a link to that also. It's got a discussion of the issues that come up, talk about many of the same things that we're talking about today. The ABA concluded in Formal Ethics Opinion 495, the purpose of Model Rule 5.5 is to protect the public from unlicensed and unqualified practitioners of law. That purpose is not served by prohibiting a lawyer from practicing the law of a jurisdiction in which the lawyer is licensed for clients with matters in that licensed jurisdiction. If the lawyer is for all intents and purposes invisible as a lawyer to the local jurisdiction where the lawyer is physically located, but not licensed. Now, this is a general statement. It's good. It can be used. But as we're going to see, the rules vary from state to state. And so you've got to pay attention to the actual law of the state where you're physically located. I'm gonna mark this. If we could move to just 1 second to the next slide, please, Andy. This is Tennessee Rule 5.5. A lawyer shall not practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction or assist another in doing so. So this is our rule in Tennessee, okay? And it says that you can't practice law in a jurisdiction in violation of the regulation of the legal profession in that jurisdiction. So that means that we've got to pay attention to the UPL rules in that state also. Okay, next slide, please. This is what I said just a minute ago, consult Rule 5.5 in the jurisdiction, the licensed jurisdiction, and the local jurisdiction. For reference there, that's a link to the ABA. The ABA has a really, really nice website about the model rules, in which each section of the model rules has a comparison chart. And for example, in that model 5.5, in that model rule 5.5 chart, it's several dozens of pages long because it has the model rule, it has the rule as adopted, rule 5.5 as adopted in all of the jurisdictions that have adopted the model rules. And you know, you've heard Bruce and myself and other people say ad nauseum since 2003 when we adopted the model rule approach in Tennessee, that you have to be careful to compare. Anytime you're looking at the model rules, looking at authority under the model rules, trying to make a decision about what kind of conduct is okay, what kind of conduct is permitted and what's not permitted, be very careful to compare the Tennessee language to the model rule language and or the rule of the state that you're looking at. So in furtherance of meeting my own criteria that I've said to you so many times in this little get together that we have each December, in the materials on the Dropbox website and that I gave to Andy to provide, there's a red line showing you the differences between ABA Model Rule 5.5 and Tennessee 5.5. For the purpose of this particular discussion, there are not that many relevant differences, but since we say to start there, I thought it best to actually start with that. Now, let's go. So the first jurisdiction, next slide, please. The first jurisdiction, as I told you, the first jurisdiction to address this is Maine, that addressed it in 2005. And the Maine Board of Bar Overseers in this opinion 189 said specifically that where the lawyer's practice is located in another state and the lawyer is working on office matters from afar, we would conclude that the lawyer is not engaged in the unauthorized practice of law. So that's been in effect since 2005 in Maine. During the pandemic, two other states, next slide, please, two other states amended their version of Rule 5.5. Arizona, a place where a number of people go to retire, I suppose. They amended their Rule 5.5 with that red language there that I provided for you, saying that a lawyer admitted it is not the unauthorized practice of law for a lawyer to provide legal services in Arizona that exclusively involve federal law, the law of another jurisdiction, or tribal law. So that I could, in that case, I could live in Arizona And I could work on my appellate practice in Tennessee or my motion practice in Tennessee and file those things electronically and not run afoul of the UPL rules in Arizona. I think there's a typo in that, but I think the word, I copied that from the Arizona Supreme Court website, so I may have hit a key there. I don't think the word by that exclusively involve federal law. I think there's the word by is a typo in that. But anyway, I'll put a link to the version in that Dropbox so you can look at the right language if you want to. The point is that in Arizona, they've specifically addressed this by court rule, by the Arizona Supreme Court, amending Rule 5.5 to provide that. I think you get into a different question when you start talking about opening any kind of office. As you'll see in just a minute in the Florida opinion that the Florida Supreme Court made, the lawyer there and the facts of that opinion was based on talk about practicing in a house so that it was not anybody could tell. I do believe, and I think that even if you opened an office where people could come and go and it had any indication that it was a law office, it would start to be a significant problem. I think most of these cases, and you're going to say there's a District of Maryland case in just a minute, most of these cases involve people working in their homes. So a big factor here is that there's very little, or perhaps in the Florida case, there was absolutely zero chance that a person physically located in Florida would see this person and think that they were a lawyer, be confused and thinking perhaps that they were a lawyer licensed to practice law in Florida. In other jurisdictions where they've adopted this in ways that were didn't go by this way that they did it in Arizona by court rule, they've relied on subparagraph F of Rule 5.5, which talks about a lawyer providing legal services in that state has to advise the lawyer's client that the lawyer is not admitted to practice in our case, it says in Tennessee, and obtain the client's informed consent to such representation. That's talking about a little bit different. Excuse me, I'm a little hoarse this morning. They talk about a little bit different situation, but what I'm driving at is in this circumstance, be awfully careful not to do or say anything that gives the impression that there is licensure in the local jurisdiction, if in fact there's not. The next state to take this up by court rule was New Hampshire. So if we can move to the next slide, please, and we'll see the New Hampshire Rule 5.5. And what New Hampshire did was add a subparagraph 3 to its 5.5D, which says the provision of legal services relates solely to the law of a jurisdiction in which the lawyer is admitted. Rule subsection D is an exception section to the general rule of Rule 5.5. And so these things, Arizona and New Hampshire are saying in their court rules that that will not be considered unauthorized practice of law if these things are relating solely to a jurisdiction in which the lawyer is admitted. You can see they chose to word it a little bit differently. Arizona said the federal law, another state law, or tribal law. Okay, next slide, please. I think this is the Maryland case coming up here. It is. So this is an interesting case. This lawyer worked for a law firm whose primary office was in Washington, D.C. The lawyer was admitted to practice before the U.S. District Court for the District of Maryland. And she had been living in Maryland, but she was no longer living in Maryland for family reasons. It says this later on in the opinion. You'll have to look at it. And I didn't put this in the Dropbox, but I'll tell you what, I'll put a copy of this opinion in the Dropbox. And you can see that this predates the pandemic. In this case, there was a question on the renewal application that said, is there anything that would prevent you from accepting a pro bono appointment in your service in the District of Maryland? And you can see what the lawyer's answer was. While I continue to practice in the District of Columbia metropolitan area, I'm employed by a law firm located in Washington. I personally reside in Cambridge, Massachusetts, moved there for family purposes. As a result, there could be times where geographically it would be difficult to take on a pro bono case in Maryland. And so the person who reviewed her application referred it to the committee of the district court that reviewed applications. They reviewed it and determined that the lawyer had established an office in either Maryland or in the District of Columbia in accordance with the applicable rules, because that person lived in Massachusetts, worked from a house in Massachusetts, took no steps to make anybody think that she was licensed in Massachusetts, did not take any cases that involved Massachusetts law, did not represent any clients in Massachusetts, and maintained her association with this law firm that had its primary office within the District of Columbia. This, again, like the main rule, is a pre-pandemic rule, but you can see there, with technology, this kind of thing is becoming more and more prevalent. And so it's going to continue to come up. And the main thing is to be familiar with these pieces of authority that have dealt with it before, so that you can address these issues. And the big issues, are, I think the key thing is visibility and location of the clients, with probably those are in reverse order of importance. Where are the clients located? Where's the dispute or transaction located? And what is the visibility of the person in the local jurisdiction? Remember, the local jurisdiction is a place where the person's actually sitting. The licensing jurisdiction is a place where the person is licensed. So this case, which is that a district court case from Maryland, found that the person had complied with the rule about maintaining an office presence by maintaining her association with this law firm that had its principal office in Washington, D.C., by not representing any clients in Massachusetts, and by maintaining her licensure in Maryland and in the District of Columbia. Okay. The next thing is what I thought was the big one, is this Florida Supreme Court ethics opinion, which I put a copy of this in the Dropbox, and I want to go through this in a little bit more detail. It's Florida Supreme Court docket number SC 1220, a Florida Bar Advisory opinion out of state attorney working remotely from Florida home. The Florida Supreme Court approved an advisory opinion and adopted it in its totality. So that they basically said the opinion of the advisory opinion was approved in an order of the Florida Supreme Court. Now, I just want to tell you, I highlighted some things in yellow in this Florida Supreme Court advisory opinion that I thought were absolutely fascinating. But the facts of it are important. So there's a fellow named, stick with me for just a minute. I'm a little bit hoarse, as I said this morning. Thomas Ristano is a lawyer who's licensed in New Jersey. He has worked as an inside intellectual property counsel for a large corporation from an office in New Jersey for many years. Decides to retire, establishes an association with a law firm whose office is located in New Jersey. And then the Florida Supreme Court gives the following factual information that the opinion was based on. And because this is important, I'm going to read to you from the facts because I think these factors are very important. And I've highlighted this for you in the document that was placed in the Dropbox. Restaino is licensed to practice law in New Jersey, New York, and before the United States Patent and Trademark Office. Okay, not licensed in Florida. He recently retired from his position as chief IP counsel for a major U.S. corporation in which he was responsible for all advice related to intellectual property, counsel the business and divisions of the company. His office was located in New Jersey when he held that job. He then retired from that job and moved from New Jersey to Florida. He started working as a lawyer with a New Jersey law firm specializing in federal IP law. The firm had no offices in Florida and no plans to expand its business to Florida. The professional office will be located at the firm's business address in New Jersey. Now, professional office means his formal office of record would be located in the firm's office in New Jersey. In other words, if somebody sent him a piece of official correspondence, it wouldn't be addressed to his house in Florida, but rather it would be addressed to him at the firm's office in New Jersey. But he will do most of his work from his Florida home using a personal computer securely connected to the firm's computer network. In the conduct of his employment with the firm, this is important too, he will not represent any Florida persons or entities and will not solicit any Florida clients. While working remotely from his Florida home, he will have no public presence, no public profile as an attorney in Florida. Neither he nor his firm will represent to anyone that he is a Florida attorney. Neither he nor his firm will advertise or otherwise inform the public of his remote work presence in Florida, The firm's letterhead and its website and his business cards will list no physical address for him other than the firm's business address in New Jersey, and will identify him as of counsel, licensed only in New York, New Jersey, and the USPTO. The letterhead, website, and business cards will show that he can be contacted by phone or fax only at the firm's New Jersey phone and fax number. Now, that's something that I think is a little bit beyond what we've seen with any of the other jurisdictions, but that's important. The letterhead, website, and business cards will show that he can be contacted by phone or fax only at the firm's New Jersey phone and fax number. Phone calls to his law firm and his extension are routed to his cell phone. While clients do not dial his cell phone number directly, petitioner's cell phone has a New Jersey area code. That's in a footnote. So it would be important there to note where people perceived that he was when they made the call. Now, everybody knows you can stick a cell phone in your pocket and carry it anywhere in the country. But I think that one of the things that the Florida Supreme Court was saying here by adopting this advisory opinion was that the perception of where the person was important. He will not work on any issues that involve Florida courts or Florida property, and he will not give advice on Florida law. His work at the firm will be limited to advice and counsel on federal IP rights in which no Florida law is implicated, such as questions of patent infringement and patent invalidity. that, excuse me, that is the list of facts upon which the Florida Supreme Court and the committee that actually drafted the opinion relied in approving this arrangement. There's a lot of, it shocked me, I guess maybe he was talking about some kind of intellectual property, because the guy actually testified, they had a hearing on this before they issued the opinion, and he testified that he did not realize this kind of technology had existed, which surprised me because he was practicing law in the patent and trademark office, and he was an IP lawyer. But be that as it may, the opinion goes on to talk about how all of his documents that he works on will be physically located in New Jersey. Now, he also said something that I thought was kind of contradictory. He said he was using a cloud-based system and the documents were located in New Jersey. I'm not sure that's 100% accurate. Obviously, if you store something in the cloud, when I've done my segment on technology in the past, I've talked to you about secure cloud systems. The one we use is called Spider Oak. I've told you about that, but there are plenty of other secure cloud systems that you can use. Those, I don't know where those documents are located most of the time, and they have server farms that are in different places. So at different times, those documents may be located in different places, but the access to them comes through the law firm in New Jersey. And so that was important to the Florida Supreme Court in deciding this. And then Florida reviewed its Rule 5.5B, which said the lawyer who is not admitted to practice law in Florida may not establish an office or other regular presence in Florida for the practice of law. And if you look at the comparison document that I gave you, Tennessee and the model rules approach, both in 5.5B, both say a lawyer who is not admitted to practice in this jurisdiction shall not, except as otherwise authorized by these rules or other law, establish an office or other systematic and continuous presence in this jurisdiction for the practice of law. So the governing piece of rule was 5.5B. And then the Florida Supreme Court adopted this language. It is clear from the facts in petitioner's request. And remember those facts that I read you were, right? He was not going to have anything to do with Florida law. They weren't going to open offices in Florida. They weren't going to serve any clients in Florida. Excuse me. They weren't going to hold himself out to be licensed in Florida. He was going to work in a private room in his own house. He was going to access the law firm information through a computer that was connected across the internet, albeit through to a computer in New Jersey. The Florida Supreme Court said this: it is clear from the facts in petitioner's request and his testimony at the public hearing that petitioner and his law firm will not be establishing a law office in Florida. It is equally clear that petitioner will not be establishing a regular presence in Florida for the practice of law. He will merely be living here. The facts raised in petitioner's request, quite simply, do not implicate the unlicensed practice of law in Florida. Petitioner is not practicing Florida law or providing legal services for Florida residents, nor is he or his firm holding out to the public as having a Florida presence. He testified, we tried to make sure that no Florida citizens, no Florida businesses, certainly not the Florida courts, would have any exposure to me or the work I was doing. All indicia point to petitioner's practice of law as being in New Jersey and not Florida. And with that, the standing committee, and then also the Supreme Court by adopting it, said that practice that work, which is located in a house. And basically you can see by the facts that it's got zero public exposure in Florida, that there's actually a lawyer there. And I think the guy would be well advised to be careful about what he says in casual conversation to people about, oh yeah, I'm retired, but I'm working down here. I wouldn't have thought that. It wouldn't have occurred to me, I don't think, to be quite that tight-lipped about it. But after reading the facts of this opinion and the way that the Standing Committee and the Supreme Court of Florida relied on those facts, I think one of the things to think about is if you say, well, it's not out of the question to think one of us would cut back and live in Florida 3 months a year out of the year and still try to keep up with some work electronically. It's so easy these days. There's so many tools that allow us to do that so easily and efficiently that it's not inconceivable to do that. But I do think that one of the things to think about is be assiduously careful not to establish any public indication. And I think included in that, no public indication, is the idea that we won't even talk about in casual conversation, really, that we're there working, even if in the privacy of our own home. It looks to me like what the Florida Supreme Court is trying to say in this thing is do not make any public indication that you are doing work on New Jersey law in Florida so as to protect people from being confused by the idea that you are practicing law in Florida. And that's a really interesting thing to think about. And it raises a lot of issues. The point is here, if you're going to do this, be careful. Look at 5.5 in Tennessee. Look at 5.5 in the jurisdiction where you're going to be physically located. Look for an ethics opinion in the jurisdiction where you're going to be physically located. And then pay attention to these things that have been important in these other cases. No public indication, no work for clients in that state. And I think this, you can see by implication in this Florida decision that the outcome might have been somewhat different if he said, well, I'm going to, we may have a client in Florida that I do some IP work for. I think there's no room for that. I think there's no room for any meetings in Florida. I think there's no room for any direct communication with people that, oh yeah, well, I'm still working at Jenkins Dedman in Dyersburg, but I'm living in Florida now. I think that has to be avoided. It has to be to all intents and purposes, to all appearances, that the person is still part of that law firm. Now, that raises a whole other set of questions about making sure not to mislead anybody. But that's a question for another day. Right now, the authority that we have in Formal Ethics Opinion 495, in this Arizona, New Hampshire rule, the main opinion, especially the Florida opinion, the District of Maryland case that I cited for you there, that what we've got is a real attention to the fact that there can't be any appearance that this person is practicing law in the local jurisdiction. And look at the kinds of things that they said. Don't set up a fax machine and tell your clients, oh yeah, well, I'm not physically at the office right now, so just fax this to me at this number and give an area code of somewhere located in Florida. Oh yeah, I've got a new cell phone number, and give them a cell phone number with a Florida area code. That footnote in the Florida opinion makes it look a lot like It probably would have been okay, probably to call cell phone with the New Jersey area code. It certainly would not be okay to call cell phone with the Florida area code. And so I'm going to finish up pretty quickly. I've talked about that a little bit longer than I wanted to, but look, also I want to encourage you, because this is something I've talked about before with the a formal ethics opinion 498. Go look at 498. I've talked about technology before. Remember, I had that little PowerPoint presentation where we spelled out encryption a couple of years ago and talked about what each one of those letters meant, making encryption into an acronym. And I thought that was a kind of an interesting way to talk about those things. But you look at 498 and you're going to see something. Basically, 498 says, look, you pass the UPL hurdle. When you pass the UPL hurdle, you've still got a duty to handle the technology competently and in a way that preserves client confidentiality, and in a way that, in other words, it almost has to be like you've got it set up so that you're in the you know, it's just almost just as safe as it was if I was sitting in my conference room right here in Dyersburg with my client. I get the same level of security electronically that I would have if I was sitting in my conference room with the client in Dyersburg. And there were two things that I thought were interesting in that, two big things. There are a lot of things that are interesting, but there were two big things that kind of caught me off guard. Number one, the ABA Formal Ethics Opinion 498 says you must read the terms of service of every one of these things that you use, Zoom or WebEx, however you do video conferencing. If you use that in your virtual practice or remote practice, you've got to read the terms of service to make sure that you're protecting client confidentiality. That's interesting. If you use a cloud-based service, you've got to read the terms of service to make sure that you're protecting client confidentiality, that there's not some exception in the terms of service. Who ever reads one of those things, right? Do we ever read them? You go down, you scroll down to the bottom of it. Every time my iPhone updates, I scroll down to the bottom of the terms of service and I make it, tell it that I accept it, right? Be careful. Be careful, because it looks like we're driving toward a regime where it's going to be incumbent upon us to actually print those things out. And I've started telling it to print them and saving them in an electronic folder, make a PDF out of them, not physically print, but save it to a PDF so we can examine it if we need to. That's the first thing, read those terms of service. The other interesting thing that I thought it said in there was be careful about voice activated speakers. In other words, be careful about things like a Google, I think it's called a Dot, Google Dot, or an Amazon Alexa. I've got an Alexa in my house. After I read an article in the Washington Post about 5 years ago that my voice recordings were, every time it heard a sound, it recorded a few seconds of voice to, one, learn, and two, make sure that the next thing that was said wasn't going to be, hey, Alexa, tell me something. You know, I went on the Amazon website. It had about 150 snippets of things from the Alexa in my house. I listened to about, I don't know, 40 or 50 of them. It was absolutely nothing. Most of it, you couldn't even tell what it was. You couldn't even tell that it was a word, but it taught me a lesson. There was something there recording me, even though it totally didn't matter. There was something there recording me. I pushed the mute button on that. I don't have an Amazon Echo in my office, but you know what? Sometimes when I get home and this client calls me on my cell phone, I sit down in my chair in the living room where that Amazon Echo is located, and I talk to my client. So I have that, I'm within range of that thing when I'm talking to a client. So I push the mute button on that thing, and if I want to use it, if I want to use it, then I have to walk over there and unmute it so that it can hear me. It doesn't like that, but I think those kinds of things are things that we've got to think about. and they're specifically mentioned in 498. So there's a copy of 498 with some things highlighted in it in the Dropbox. You want to go look at those things. I think I'm out of time. In fact, I've gone 4 minutes over, and I apologize to Andy and Laura, and I will be quiet now. Thank you very much. And also I want to thank Bruce, because my voice was hoarse this morning. And so instead of talking for an hour, I only wanted to talk for 45 minutes. And my friend Bruce Smith agreed to take up 15 extra minutes. So I'd like to say thank you to Bruce for doing that for me.
Glad to do it, Lewis, anytime. And just as you're uploading or asking Andy to upload additional materials into the Dropbox, I've just sent Andy a version of my handout. I found several typographical errors, and I've corrected them. So attendees, if you so desire, please get the corrected version, which hopefully Andy will be able to upload before we adjourn for the day.
Hey, Bruce, I have a separate Dropbox that I made. If you want to shoot me that thing by email, then I'll upload it there also if you want to.
It's already, I've already sent it to you and to Laura.
Okay.
I've already put the new one up in the Dropbox that was sent out to everybody. So
Thank you.
that's good. We will take our required break, everyone, and we'll be back at 2:45 to finish up with our last presenter.
Thank you.
All right, everybody, we are going to go ahead and get back started with our last presenter of the day. Laura, you should be able to share your screen for the PowerPoint. If you have any issues, just let me know.
Okay, let me see, just a second. Okay, can you hear me and see this?
We can hear you. I'm not seeing a PowerPoint on the screen yet.
Well, that's what I'm seeing, so I can tell you. I'll escape out of it just a second.
Yeah, I'll try again.
Okay, I have it up.
And then have you clicked to share screen in the bottom?
No, let me see. That's probably what's wrong, but I don't see where to do it.
So in the middle of beside chat and between raise hand, there's a button that says share screen.
Yeah, I've seen it now.
Okay. There we
Okay,
go.
now you see
Yeah,
it.
we got it.
All right, let's see. Okay, how's that?
Looks great. Thanks, Lori.
All right. Sorry with the problem to get started here, but I guess you've been listening for a while, so I'll try to make this a little bit interesting. I have a surprise issue to bring to you today. And it's wellness. I mean, that's not usually part of the ethics presentations that we do. We're usually talking about ethics rules. And this really does apply to the ethics rule of competence, because as you know, you have to bring competent representation to your clients. And certainly wellness, if you're not well, you don't bring everything that you need to do for your clients. And it has become a big issue since COVID, because with the changes in practice that's been brought about by the pandemic, with everybody having to learn how to work remotely, there have been big changes in the law because of that. And it has been very stressful for lawyers and clients alike. And since 2016, the ABA and the lawyers' disciplinary jurisdictions have all known that lawyers have a real problem and that they are disproportionately impacted by mental health concerns and substance abuse. That study was done with the ABA in conjunction with the Hazelton Betty Ford study, and it found that large percentages of lawyers suffer from depression and are problem drinkers. And so the remote work has made this even worse. And there was a whole, I don't know how to get that off of there now. Okay, there was an article in the American Bar Association in August last year that talked about the mental health risks of remote work, and that the pandemic had forced remote work, and two prominent concerns came to the fore. One was isolation and the other was burnout. And loneliness is a potential setback of remote work. especially if you aren't getting much interaction from friends and family or elsewhere in your personal life. Some law firms or government offices are still only working remotely. I know that the administrative office of the courts, for instance, is still working remotely. And our office, 2 days a week, we work remotely. So this is a problem because you can just get into this loneliness cycle. And so it's important to keep up your social relationships and try to make time to be with friends. The Texas Bar Journal came up with an article. The president of the Texas Bar, Laura Gibson, wrote this article about inviting a lawyer to lunch and saving a life. And I thought, wow, that's pretty substantial saying there. But the American Bar Study showed that of almost 13,000 attorneys, 32% of attorneys under the age of 30 reported having a drinking problem. 21% of the attorneys had more of a drinking problem than the rest of the population over the age of 25. And so she says in her article, these numbers were bad before COVID, and what the bar is seeing now is that attorney stress is at all-time levels. And she was saying that you can help lawyers in your community by inviting a fellow lawyer to lunch. She says, loneliness is killing us. People who have contemplated suicide have indicated that they wouldn't have if they believed even one person cared about them. She says that, lawyers used to show up on Fridays for docket calls, but when the courthouses shut down for most of the pandemic, particularly the civil court proceedings, and that civil trials weren't being held, and that the jury trials were pretty much vanishing, she said, we need to bridge the gap by reaching out to our lawyer friends and inviting them to lunch, because they used to be able to meet at the courthouse and talk and see about what's going on with each other, but now they don't. So she said, don't wait. Loneliness is killing us. Call one of your friends, your lawyer friends, and invite them to lunch and offer them words of encouragement. And believe it or not, your simple act could save a life. The next slide you're seeing is getting serious about legal burnout. And this was an article, many of you may have read it. It was in the TBA Journal in May, and the May-June TBA Journal, about what you can do. What is burnout? What can you do about it? So we talked about isolation, but then there's burnout. And so there was a story that they published there, and I'm going to read it to you because I think it's very, very important. It's called Becky's Story. I was a 26-year-old newly minted attorney chasing her dreams in Washington, D.C. To the outside observer, I had it all. Headhunted into a morally uplifting big law job in my chosen practice area of federal Indian law. I had a view of the Washington Monument from my top floor office, and I had a paltry 1,600 billable hours requirement, and I had arrived. Fast forward 2 years into my dream job. Every time I could hear the email alert ping on my phone, my stomach painfully contorts. I come home each day and explode in anger when asked about my workday. Formerly bubbly, active, and social, I only have energy to zone out and watch TV until it's time to pass out and repeat. Just repeat, no rinse. There was not a lot of personal hygiene going on during this period. Ultimately, my big law career in DC came to an untimely and unceremonious end. The unresolved burnout, depression, and anxiety had finally coalesced to derail years of academic achievement, training, and investment in my legal career. It was the first time in my life where I felt like I had failed to achieve what I set out to do. I entered solo practice, moving to northern Arizona, where I was able to focus on healing in mind and body and spirit, prioritizing physical activity, work-life balance, reconnecting with nature and rest. This is also when I found mindfulness and meditation that have truly transformed my life. This experience also inspired me to become a certified meditation instructor and able to help others to cope with stress, burnout, and mental health concerns. It took long, prolonged, dedicated effort, but I was finally able to accept and understand that I wasn't deficient. I wasn't a failure as an attorney or a person. I was a victim of burnout, an experience so common among attorneys that it has seemingly become part of our professional culture. We issue a personal challenge to our readers: constantly examine your work environments and the culture that we've created in the legal field, and ask yourselves, is this what we want to be? Because ultimately the choice is ours. And then they go on to talk about how to identify burnout. And so on your screen, you see some things that the Mayo Clinic has determined are signs of burnout: becoming highly cynical or critical, having difficulty focusing, feeling disillusioned or dissatisfied, exhaustion, insomnia, stomach or bowel problems, changes in appetite, frequent headaches. These are all signs of burnout. They also said that the biggest causes of burnout from a Gallup poll's data show that unfair treatment at work is the #1 cause. Unmanageable workload, lack of role clarity, lack of communication and support from superiors or supervisors, and unreasonable time pressure. And I think we all know what that is like, whether we are supervisors or whether we are not. The unreasonable time pressure that is put on us as attorneys really can lead to burnout. So to avoid it, what do we need to do? Well, for one thing, we found that people that are working remotely, believe it or not, it's not uncommon that you work longer hours than you would in the office. Because at the office, there's a certain time you come, a certain time you leave. But at home, you're just kind of thinking of something you need to do about a case and you go do it. And so you're ending up working more than you should. And it becomes everything you're doing. So you need to set clear work boundaries. Set times to turn off your notifications. I know people that never turn off notifications. And so the ping of the alerts is going off all the time. And this is just stressful. You need to create a dedicated workspace and just work in that space. Don't be all over the place with your business things, with your papers. And then set regular business hours, just like you would if you were going to the office. And so when you're working remotely, don't let it get out of control. This also applies if you're in the office. When there are regular business hours, try your best to keep up with those and leave when it's time to go home. Laura Gibson also put in another article just last week in the Texas Bar Journal. And the reason I'm using that is I'm licensed in Texas, so I get their bar journal as well. But the name of the article is Secure Your Own Oxygen Mask First. And she was talking about compassion fatigue. You know, you see so many people that are having personal problems in their lives and in their professional lives. As lawyers, they put all their problems on you because you're going to fix this for them. And she says it comes to a point when you can't remove yourself from this, that you have compassion fatigue. You're tired of hearing about all of these things. And she said the best way to get over that is to take care of yourself more. She said the third leading cause of death, now this is unbelievable to me, in the legal profession is suicide. Does that strike you as shocking? The third leading cause of death in the legal profession is suicide, only behind cancer and heart disease. So what she says is you need to focus on some things that you love. Self-care. You know, make time for a daily walk outdoors. Surround yourself with people that make you happy and positive, and renew your feeling of optimism that way. She said that, you know, this article concluded right before Thanksgiving and said she has so many things to be thankful for, but she said thinking about self-care is one of them. And so sometimes she will even take a day off just to meditate or be mindful and try to get her life into control, and suggest others do the same. So how do you recover from work stress according to science? I skipped a thing. Yeah, I think I have. This says that you need to combat stress and burnout. And to do that, employers are increasingly offering benefits like mental health support, spontaneous days off. And even with these efforts, the workforce is not thriving. Only 32% of employees across the board say they are thriving, and 43% report high levels of daily stress. Some reports have up to 61 of US professionals feeling like they're on the edge of burnout at any time. And this is from the Harvard Business Review in July of this year. So to manage legal burnout, they suggest, this Harvard article suggests, to set aside time to examine whether you are exhibiting any of those signs of occupational burnout. You know, go back to that list and say, am I exhibiting this? And if so, make a decision to take charge of all aspects of your life. And then consider where you could adopt more productive lifestyle habits. Investigate and take advantage of available resources. Number one, it is so important to mentally disconnect or switch off your work thoughts. You may be going to the gym and working out in exercise class, but it's not helping you at all if all you're doing is thinking about what happened at the office or what happened in a client meeting. And research shows that even if you are working out, thoughts about work detracts from your ability to recover from it. So you have to give your mind a break. Think about something besides work. The second thing is easy to do. It's to harness the power of micro breaks during the workday. Contrary to common assumption that recovery can only happen after you've had a long vacation, that science has found that micro breaks, short breaks of approximately 10 minutes during the workday, are surprisingly effective from recovering from daily work stress and various job demands. So get up from your desk, walk around, get a drink of water, talk to somebody, do something for 10 minutes other than just working on your work. And then the third thing is consider your preference for recovery activity. The author says that she used to go with her partner, with the partner's hobby being guitar lessons, and she suddenly realized she dreaded going to guitar lessons. She didn't want to play the guitar. She said now she and her partner do their own hobbies. Her hobby is gardening. And so she does gardening, her partner does guitar lessons, and then they carve out time to spend together afterwards. So be mindful how you use your lunch breaks. Use those free slots doing recovery activities that you prefer. And then try to prioritize high effort recovery activities. This multinational health executive said that he had never been rah-rah about going to the gym, but he said he had never regretted it afterwards. So while it may seem that like passive low effort things like watching TV or just sitting around chilling is best for recovery, science has said on the contrary, the more active the activities are, the more they are effective for recovery. So if you don't enjoy going to the gym or playing team sports, you can find a type of exercise that you do like a fast walk or a hike or a swim. Then it says, shape your environment for optimal recovery. Research on direct exposure to nature, such as park walks during the workday, lunch breaks, those kind of things, shows that it can enhance your recovery from stress. In as little as 10 minutes, You don't need to book a trip to the mountains. You can stay connected to nature while at work by using any outdoor facilities that your employer provides, like cafeteria terraces or green spaces at the building entries, or just taking short walks outside. Where my office is, there's a courtyard in between some buildings, and there are trees there, there's benches. And many times I'll go out there for just a few minutes and sit there and listen to the birds and just chill out. And it really is helpful, just for 10 minutes. There was a news article, and this was on CNN in September of 2022, that exposure to green spaces and water, even virtually, boosts your mental health. I mean, look at that picture. Doesn't that make you feel calm? Doesn't it make you feel good? There is an abundance of online videos with soothing water sounds. This is just one of them. This is a babbling brook, but you can get them that have ocean waves, that sort of thing. And if you just calmly listen to this, it may help you. Now, it was very interesting when I showed this in another CLE. A man in the front row stood up and said, "That sounds like a leaking toilet and it's stressing me out." So that's pretty funny, but in essence, listening to water really does calm you. Think about adding a green plant to your office. I have some scraggly green ones in my office, and it just makes me feel better to look at them because they're growing, they're happy, they like the sunlight. So if you have a chance, put that in there and see how it makes you feel. It's supposed to, by science, make you feel better. The benefits of devising and enacting an intentional recovery plan. There are a lot of benefits. You can sustain your well-being. You can sustain positive moods, and recovery can boost your cognitive and physical performance. Another thing that is good for your health, and you may think this is crazy, but it's pets. Research has shown that pets lower your stress. Pets are always there. They don't talk back. They listen to you and never judge you. But did you know they can also benefit your health? Centers for Disease Control and Prevention have found that having a pet lowers your blood pressure, cholesterol, and triglyceride levels. And depending on the pet, it also gives you a chance to socialize, exercise, and spend time outdoors, which may help with stress and improve your physical and emotional health. Owning a pet also gives you a chance to start a conversation with other pet lovers too. Unfortunately, when you need to recover is when you are least likely to engage in recovery activities. So you need to set up an intentional plan before you get really, really stressed so that you can sustain yourself with energy and performance over time. So I hope you've taken some of these things to heart and that it will help you, because wellness really does have something to do with your confidence and your legal presentation to your clients. Okay, so we're going to go into the ethics update. I know Bruce Smith has talked about a lot of things. I hope I don't copy what he's talking about, but the advertising rules have changed. That's a big deal. I talked about it last year a little bit, but I know that people really don't know this because I get calls all the time. As you know, I'm ethics counsel, so people call and ask me questions about what is ethical in advertising. And it's very clear that when people call, they're looking at the old rules, not the new rules. So in September of 2021, the Supreme Court set down an order where they adopted revisions to all of the advertising rules. And the first thing and the basic thing to remember is just don't do anything that's false or misleading. So truly, that is the basis of all the advertising rules, that you not have any false or misleading communications about you or your services. And then you have to remember to keep a copy or recording of each of your advertisements for 2 years after the last dissemination. The court deleted Rule 7.2, 7.4, and 7.5, which talked about the areas of expertise and specialization, firm names, and the record of advertising. All of those things were moved to the comments under Rule 7.1. The wording is the same, but they are now comments as opposed to a hardline rule. 7.3 was the solicitation rule, and the court completely deleted the old rule and put the new rule into effect. And so the solicitation is defined as a targeted communication on behalf of the lawyer that's directed to a specific person and that offers to provide or can be reasonably understood as offering to provide legal services on a particular matter. And then the B part of this is like the old rule. It says you can't solicit by live in-person solicitation when you're trying to solicit business. However, there are exceptions. Some of the exceptions are the same and some are different. The first one, if the person you are soliciting is a lawyer, you can do that live in person. Secondly, and this is a new one, if the person you're soliciting routinely uses for business purposes the type of legal services that you offer, you can do this by in-person solicitation. 3, you can do it pursuant to a court-ordered class action notification. If you're trying to solicit people for a class action, you can do that in person. And then, as always, this was in the old rule, if you have a family relationship, a close personal relationship, or prior professional relationship with this client, then you can contact them in person to solicit their business. The D part says the lawyer shall not solicit professional employment from any person. Okay, and this was in the old rule, if the target has made known to you that they don't want to be solicited, or if the solicitation involves coercion, duress, harassment, those types of things. And then if the significant motive for your solicitation is pecuniary gain, the 30-day rule is still in effect. If it's to do with a personal injury, a divorce, legal separation, workers' comp, wrongful death, or otherwise a disaster or an accident, you cannot contact people to solicit their business more than 30 days after it has happened. So, and you can't mail them any communication less than 30 days from the time of the accident or whatever it is. And again, you have to keep a copy of each written solicitation that you make for 2 years after you disseminated it. Paying others to recommend a lawyer. It was always that you couldn't give anything of value to someone to recommend you as a lawyer. However, now you can give your employees or other lawyers in your same law firm compensation for recommending your services. You can pay a reasonable cost of advertisement, the usual charges of a registered intermediary organization. You can pay for a law practice in accordance with Rule 1.17, where you're selling a law practice. You can pay a sponsorship fee or contribution to a nonprofit organization where you'll be given publicity as a lawyer. And then, this is something totally new, you can refer clients to another lawyer or non-lawyer professional pursuant to an agreement that's not otherwise prohibited under these rules that provides for the other person to refer clients or customers to you. So this is like a reciprocal referral agreement. It can't be exclusive, and the client has to know of the existence and nature of the agreement. So if you have a non-lawyer, such as a real estate agent, and you want to send clients to them for real estate closings, you can have an agreement with them that you'll send clients to them and then they send clients to you for legal work to do with real estate or CPA or any of those things. And as you know, it used to be that we couldn't have referrals between chiropractors and lawyers. Well, you can do it now, but remember, you can't have a referral agreement that's completely exclusive. You'd have to have more than one person you're doing this with. And the client would also have to know what is the nature of the agreement. Rule 7.4, where we used to talk about our areas of expertise and specializations, that's been deleted and moved to the comments. And the summary is that you can advertise areas of practice, but you can't communicate that you are some kind of expert or that you specialize in that type of law, unless you actually have been registered or certified by the American Bar Association's House of Governors with a certification that you have then filed with the Tennessee Commission on Continuing Legal Education and Specialization. And as the old rule said, lawyers cannot state or imply that they've received any certification from the Tennessee Commission on Continuing Education and Specialization. Firm names were deleted. It was moved to the comments, and the same wording about firm names exists under 7.1. And then Rule 7.6 was the intermediary organization, and the court deleted and replaced that. And an intermediary organization is defined as a referral service, an insurance provider, an agency that performs referrals but has no responsibility for what's happening when they've been referred. So it used to be that these functions and the actions of the intermediary organization was on the Board of Professional Responsibility to govern, but that really wasn't working out very well. And so now it's considered that it's the lawyer's duty. And if the lawyer discovers that this intermediary organization is in non-compliance with the lawyer's professional obligations, they have to withdraw or seek to correct non-compliance. And then if the organization fails to correct the non-compliance, the lawyer has to withdraw from participation. So that's all in Rule 7.6. There's a new section to the trust account rule. People know that there's a new section, but they're confused about it. The new section is Section F, 1.15F, the trust account rule. And it's basically if you learn of unidentified funds in your IOLTA account, in other words, you don't know who these funds belong to, and you've made periodic efforts to identify who these funds belong to for a period of 12 months, and you still can't figure out who owns the funds, then you can send those funds to the Lawyers Fund for Client Protection. For those of you that don't know what that is, it is a fund where people whose lawyers have stolen their money can apply for reimbursement. Of course, they're not reimbursed to the extent of the stolen money, but they do get some money back. And so $10 every year of your dues goes to this fund. And it's, pretty much getting depleted because of some lawyers that we had that really stole a lot of money from their clients. Last year, it was over $1 million that was paid out of the fund to people whose lawyers stole their money. So this is a great place to put money from the IOLTA account that you don't know who owns. Now, what's confusing to people is sometimes people have money in their trust account that they know the owner, but they can't find the owner. So say Susie Smith has $1,000 in your trust account, but she's just dropped off the map. You can't find her anywhere, and you have made all kinds of attempts to find this person, and it's in your trust account. Well, that doesn't go to the Lawyers Fund. That goes to the state of Tennessee under the Abandoned or Unclaimed Property Act. So there's a big difference there. The lawyer's fund only gets the money from the trust account that can't be identified. Nobody knows who owns it. And I will say that it's good to know that if you later find out and somebody makes a claim to you that you know who the money belongs to, the lawyer's fund will give the money back to you. On our website, there is this form, and you just fill it out, the amount of the funds to be sent to the lawyer's fund, who it is, the date of remittance, and then the person has to certify that it's been at least 12 months after the discovery of unidentified funds and that you can't determine who owns the funds. And so you sign that and you date it and you send it in. And then there's a footnote out there that says, if later you find out who owns the funds, it will be sent back, and that no charge of misconduct would come from saying you don't know who owns the funds. This is the current Board of Professional Responsibility. I know many of you know these people. The board consists of 9 attorneys and 3 public non-attorneys. Floyd Flippin is the current chair, and Jennifer Hagerman of Memphis is the vice chair, and Sheriff Floyd Bonner from Jackson is a lay member. Senator Richard Briggs is a lay member. District Attorney Jimmy Dunn is on the board. District Attorney Stacey Edmondson is on the board. Ruth Thompson Ellis from East Tennessee, Charles Grant from Nashville, Barbara Medley from Middle Tennessee, Juanita Patton is a banker and she's a lay member, Jody Pickens, District Attorney, and then Bridget Wilhite. These are the current board members. Last year, 1,583 complaints were received by the board. This is an interesting pie chart. Look on here about the neglect or failure to communicate. 53% of the complaints were for neglect or failure to communicate. And that's way up. I mean, it's always been big, but this is way more than it has been in the past. I think it's because of the remote work. I honestly do think that has caused more neglect and more failure to communicate with the clients. Also note that the complaints on conflict of interest are only 5%. And I'm going to show you some reason that I'm bringing that to your attention. Keep it in mind. The resolution of the formal disciplinary proceedings, and these are complaints that turned into formal hearings. There was 1 dismissal, 6 public censures, 15 suspensions, 8 disbarments. And by the way, as you know, disbarment now is permanent. You can never be reinstated. You're never eligible if you were disbarred after July 1st, 2020. And Tennessee is only one of 8 states that have permanent disbarment. Along with that, Tennessee is the only state that has 10-year suspension. Maximum suspension is 10 years. So the thought was that maybe people would get suspended for longer instead of disbarred, but we don't think that's happening because, like I said, last year there were 8. 9 transfers to disability inactive. And this is where the lawyer says, I'm in this petition for discipline and I can't defend myself because of some health problem, some mental problem, and the doctors send a letter, and so they transfer to disability inactive. That stops the disciplinary proceeding, but it doesn't go away because if the lawyer ever gets reinstated to active practice, then the lawyer has to go back into the disciplinary matter and get that resolved. There were 9 temporary suspensions last year. Unfortunately, many of those were for misappropriation, but also for failing to answer. I mean, that seems so basic that you would never fail to respond to a complaint, but there were several where the lawyers just didn't respond. There were 11 reinstatements and then 2 others, and I can't tell you what the 2 other things were there, but I do believe it was the persons died during the disciplinary proceeding. So there was nothing else that happened. Now, this is disposition of the complaints that didn't get to the seriousness of petitions. This should give you comfort because 43% of those complaints were administratively dismissed. And that means that you never even heard about it. If you're a lawyer and you were complained about, when the chief looks at the complaint, if everything in that complaint is true, but it wouldn't be a violation of the rules of professional conduct, it's administratively dismissed. And 43% of those complaints that didn't end up in the formal discipline are dismissed for that reason, because there is nothing that would be a violation of the rules. So you can see a lot of people complain because they're unhappy with the outcome of their case, but there was not any violation of a disciplinary rule. Then there are 41% of investigative dismissals. So once we looked into it, we found out that there was no reason for the complaint. So it was dismissed because the client didn't understand, didn't know what they were saying, or just basically were lying about what the lawyer did. And so when the lawyer defended themselves, those were dismissed. And then you can see some people were placed on retired status with their cases, and that's where there's a civil proceeding that's going on. That's just like the disciplinary proceeding. And so we wait until we see what happens in the courts before finishing those. So 3% of those complaints were placed on retired status. 2 of those lawyers took disability inactive status, or 2%, I'm sorry. And then informal public censures, 3%, private reprimands, 2%, private informal admonitions, 2%, and then diversion, 3%. And diversion is not a discipline. Anybody that gets diversion doesn't have to say they were disciplined, but it's something that was very minor misconduct, and they can do something to correct it. For instance, they didn't keep good records of their trust account, but they didn't take any money. They just didn't keep good records. So they might be diverted to the board's trust account workshop. And so if they complete that, that's all there is to it, and they don't ever have to say that they received discipline. By the way, if anybody has questions, please somebody tell me, because I can't see the chat. Now, remember I said, remember about the conflict of interest and the neglect. Remember 53% of the complaints were for neglect. And then look at the neglect questions that we got when these inquiries were made to the board, 0.27%. Then look at the conflict of interest. And remember, there were only 5% of the complaints that were of conflict of interest, but there were 31.95, almost 32% of the questions were about conflict of interest. So apparently lawyers know that what they don't know, and they call about, do I have a conflict? And because they do that, very few cases of conflict of interest turn up in complaints. We had some recent disciplinary complaints or disciplinary actions. And I know everybody knows about this, but it is a unique case, the case of Winston Sitton. And the very first sentence of that case is just so good. This case is a cautionary tale on the ethical problems that can befall lawyers on social media. And so this is what the Supreme Court was saying about that. And if you remember, this is the man who was Facebook friends on social media with somebody he didn't even know. It was just Facebook friends. And so she had asked, was it legal to carry a gun in her car? And he gets into telling her that, you know, you could have a taser or you could do anything like that. But if you really want to do something, you get this person that you're wanting to. The problem was she wanted a gun in the car because she said the father of her child was, you know, bothering her and was in an abusive relationship with her. So then Mr. Sitton advises her, if you want to kill him, lure him into your house and claim he broke in with the intent to do you bodily harm and that you feared for your life. Even with the new stand your ground law, Castle Doctrine is far safer basis for deadly force. So in replying to his Facebook comments, the friend said, "I wish you would try." Then Mr. Sitton said, "As a lawyer," remember that, "as a lawyer, I advise you to keep mum about this if you're remotely serious. Delete this thread and keep quiet. Your defense is that you're afraid for your life. Revenge or premeditation of any sort will be used against you at trial." So the hearing panel found that Mr. Sitton violated the rules of conduct 8.4A and D, and that they recommended he be suspended for 60 days. Well, this was such a unique case. We didn't have any comparative discipline to even look at, so nobody appealed. Mr. Sitton didn't appeal, the board didn't appeal. But it goes to the Supreme Court, and the Supreme Court is the final say on discipline in the state of Tennessee, and they looked at it and said, this is totally insufficient discipline. So they had both sides brief it, and then they gave this man who had gotten a 60-day suspension, 4-year suspension with 1 year to be served as active and the remainder on probation. And the court ordered him to pay costs associated with the case. And I think he also had to have a practice monitor. So that is just something he had done, and saying as a lawyer, he was advising this person. And so the court said that this was just really terrible because it made the courts, the whole bar look bad, that people were out to create alibis for their criminal clients. And that is not what they wanted to see happen. So that was the Sitton case.
And Justice Kirby used language that is a good reminder for everyone. Lawyers must remember that when they are posting on social media, they are dealing with live ammunition.
That's pretty good. Okay, the next case, Bruce, did you talk about the Charles Walker case?
I did not.
Okay, Mr. Walker was involved in some really bad situation where he was buying back properties that were sold at tax sales. He was trying to get them back under the statute that lets you pay if you own it after someone has bought it at a tax sale. And so he had a friend or someone that worked for him that he would say was the owner, and he would get that person to sign a document, or he said he got that person to sign a document giving him ownership of this property. And then he would try and get it back from the courts. So it turned out that the person that he was having doing this was somebody that just worked on his building, didn't have any interest in the property. So it was a complete scam. And so this whole thing was happening in the Chancery Court, where people were very upset about him trying to take these properties. So the court said, while this case is going on, you can't do this anymore. You cannot sign any deeds. You can't file anything in the registrar's office without telling this court or opposing counsel. And what he did was he kept doing it. He kept filing things with the Register of Deeds. And of course, it came to the court's attention, and he got in very big trouble for that. And eventually, he was even under a temporary injunction not to file anything, and still did it. So the court found him in criminal contempt. And then when this went to disciplinary proceeding, it was found that he would be suspended for 3 years with 2 years to be served on active suspension, 1 year on probation under the supervision of a practice monitor. Then we had a case of Tyree Harris. And this is an interesting case because it wasn't a direct misrepresentation. However, Mr. Harris, intentionally omitted relevant information fairly called for in the questions in a deposition. The Supreme Court found that the answers were carefully crafted to give the appearance of literal truth, but were in fact dishonest in that they intentionally omitted relevant information fairly called for in the questions during this deposition. And this was all to do with child support. So the hearing panel found that Mr. Harris had a prior unblemished career of 40 years. And so this is where a lawyer was trying to be their own lawyer. And you can see he had a fool for an attorney because he was lying throughout the whole matter in a way that was not a straight out lie, but was dishonest. And so the panel said he should be disbarred, but because he had never had any discipline in 40 years of his legal career and that he was retiring, they gave him a 1-year suspension. But he really engaged in fraud because he had gotten $225,000 for a case. And he claims that he was holding it because there was a dispute over expenses with his firm. But he had put the money in his trust account. And he answered in a deposition and said, I have not drawn anything from the firm with the single exception of my child support. I have not drawn a penny from the law firm. Well, he was saying because they hadn't agreed on the expenses that he hadn't taken that money. But the court said, once he put that money in his account, he deposited it in his personal bank account, that he had control of it. And so he did have $225,000 that he had received that year. So it was dishonest conduct, and that was how he was treated. And the last case is the case of Ms. Pruitt, Candace Pruitt. This actually is one of the few conflict of interest cases that we've had lately. In this case, Ms. Pruitt had a boyfriend, and he and another man worked at a tavern, and they got shot one night while working there. She didn't tell, she started representing both of them. She didn't tell her boyfriend that, she might have a conflict of interest and ask him to sign any sort of informed consent to that conflict. She didn't advise them that they might want to file workers' comp instead of assault. I think she filed for assault. And so it went along, and then she and the boyfriend got crossways with each other. And so she just didn't do anything on the case. Then it got to where the case was going to be dismissed, and she had to give expert findings. And so the stuff that she turned into the court got dismissed because it was so bad. And so the Supreme Court found that she really had a conflict of interest because she had this romantic relationship with the client. The other client didn't know about it either. And at some point in time, the attorney and the boyfriend broke up because she ended up pregnant with the boyfriend's child. And so he then wanted his file to go to somebody else, another attorney. And she says, okay, I'll give you the file, but you have to put a $121,750 lien on it for my fees. And of course, nobody would take the case with that on there. So eventually she did take that off, but she hadn't had any prior discipline. And so she was suspended for 30 days. I'm sure you all have talked about or heard about the proactive management based regulation. This is a voluntary self-assessment program where you can earn 3 free CLE credits. To date, 1,778 attorneys have taken the PMBR. It's something you do online, and you get a certificate at the end from the company that puts it out, and it helps you know what you need to do in your law firm. This is a screenshot of our website. If you click on for legal professionals get started, this page comes up, and if you go clear down on the right-hand side, you see Tennessee's proactive management-based regulation, voluntary self-assessment. If you click on that link, it comes up and you can take it, and you don't have to do it all at one time. You can take pauses in it and go back, but if you complete it and you send the certificate to the CLE Commission, you will get 3 free CLE hours. While I'm on this page, I want to show you over by ethics opinions, down clear near the bottom where it says informal ethics inquiries. If you click on that, a form comes up and you can put your facts and your questions on it. It comes directly to my computer, or if I'm not here, to another disciplinary counsel, and you will get an opinion back, an informal opinion in writing that you can put in your file. It's always good to have a record. We make a record of every phone call, every ethics opinion that we give by email or online. So there's always a memorandum, but it's always good to have it in writing. And this is the way to get it in writing. This is more about that self-assessment, just says, you know, the things that it assesses. And then there's an example of a question, and then you would fill it out and answer the questions. And then when you answer it, on the right-hand side, there's the ethical implications, the rules, or the cases that have to do with that particular thing. And lastly, I'm going to talk about this. What could be coming in the future? New York has become the first state to mandate CLE in cybersecurity, privacy, and data protection. So all attorneys in New York now have to comply with getting this CLE credit for, they have to complete 1 hour of training every 2 years in either the ethical obligations surrounding cybersecurity, privacy, and data protection, or in the actual technological and practice related aspects of protecting data and client communications. Technology competence is across the country. In 2016, Florida required people to take technology competence CLE once a year. Then North Carolina in 2018 has mandatory technology requirements in CLE. So I wouldn't be surprised if Tennessee sometime soon has the mandatory requirement for learning about technology and ethical obligations there too. So I'm right at the end, and this is the time for questions. Do I have any?
There's no questions in the chat. If you have any questions, go ahead and ask them before we end for the day.
Okay, Andy, I guess there's no questions.
Yep,
It's been nice to talk to everybody. I couldn't see them. I would like to see them.
Well, Laura, thank you so much. There's not any questions, so we'll go ahead and end. I will quickly put the link in the chat to get your CLE credit. It should also be in an email that was sent out. Give me just 1 second. And then if anybody has any issues with the link to get credit or needs anything, you all have my email address and feel free to reach out. But if not, you all have a great day. And Laura, Lewis, and Bruce, thank you all for presenting again.
Thank you. It's a pleasure.
Thank you very much. Always great to be part of this outstanding program.
All right, y'all have a good day.